Right now, the United States Supreme Court is sitting on two loaded guns, and by late June 2026, both of them are going to fire. When they do, gun carry laws in Hawaii, California, New York, New Jersey, and Maryland could be wiped off the books overnight. Millions of concealed carry permit holders who are currently treated like criminals for walking into a grocery store with a legal firearm could have their rights fully restored. And the entire framework that anti-gun states built after the 2022 Bruen decision, designed specifically to gut that ruling from the inside, could come crashing down in a single Supreme Court opinion. Every fact I'm about to give you comes directly from SCOTUS blog, the Cornell Legal Information Institute, Everytown, NRA ILA, Bloomberg Law, the Duke Center for Firearms Law, Ballotpedia, and the official Supreme Court docket. This is the real story. Let's break it down. To understand what is about to happen, you have to go back to 2022. In Bruen, the Supreme Court, in a 6-3 decision, struck down a New York law that required a permit to have a gun in public and necessitated that a person show a safety need for that permit. Justice Clarence Thomas wrote the opinion for the court, establishing that in order to pass Second Amendment scrutiny, a law must be consistent with the nation's historical tradition of firearm regulation. That ruling was a seismic shift. Federal appeals courts in 2026 are still navigating a legal landscape that is coming into focus after Bruen. As one University of Chicago law professor put it, every time the Supreme Court takes up one of these cases, there is a meta-question about how to apply the Bruen framework to any Second Amendment question. And depending on how opinions are written, they are likely to have significant effects on how lower courts decide cases on Second Amendment issues. But here is what the anti-gun states did immediately after Bruen. Rather than comply with the ruling, they found a clever workaround. A handful of states, including Hawaii, defied the Supreme Court by passing laws that supposedly conformed to the Bruen opinion, but that made carrying a firearm in public just as difficult, expensive, and impractical as before. The most audacious of these maneuvers was what became known as the vampire rule. The vampire rule. You need to understand this term because it is at the center of the most important gun case currently before the Supreme Court. Gun laws like Hawaii's are often called vampire rules because, like the rules that applied to vampires in Bram Stoker's Dracula, they keep out a deadly threat unless the deadly threat receives an explicit invitation to enter. Hawaii enacted its law in 2023 in response to the Bruen ruling. Here is exactly how the law works. Hawaii's law bans gun owners from bringing their guns onto private property that is open to the public without specific permission from the property's owner. Think about what that means in practice. The Department of Justice's brief to the Supreme Court described it this way. In Hawaii, concealed carry licensees who stop for gas with a pistol in the glove compartment risk a year in prison if they fail to obtain the gas station owner's unambiguous consent. The same goes for licensees who run errands at grocery stores, dine at restaurants, or stop to buy coffee. A mere nod from the property owner, or an insufficiently conspicuous sign, puts license holders at risk of prosecution, even if the owner welcomes firearms, but failed to express approval clearly enough. And Hawaii is not alone. 4 other states have similar laws: California, Maryland, New York, and New Jersey. That means 5 of the most populous states in America are all operating under the same legal framework, one that could be declared unconstitutional in a single Supreme Court ruling expected by the end of June 2026. The case is called Wolford versus Lopez, and it is already fully argued before the Supreme Court. The plaintiffs challenging Hawaii's law are 3 Maui residents, Jason Wolford, Allison Wolford, and Adam Kasperzicki, along with the Hawaii Firearms Coalition. They contend that Hawaii's default rule effectively nullifies the public carry right recognized in Bruen by turning ordinary publicly accessible destinations such as stores, restaurants, and parking lots into presumptive no-carry zones. Hawaii Attorney General Ann E. Lopez, meanwhile, argues that the Second Amendment does not confer a right to carry a firearm onto another person's property without consent, and that the statute simply codifies owners' long-standing authority to exclude firearms on their private properties. On January 20, 2026, the U.S. Supreme Court heard oral argument in the case the federal government, under the Trump administration, came down firmly on the side of gun owners. Attorney General Pam Bondi stated that Hawaii's law plainly violates the Second Amendment. The DOJ's brief argued that the government cannot enact licensing regimes that effectively eliminate the right to public carry, and that the right to carry a handgun for self-defense outside the home ranks among the core protections of the Second Amendment. During oral arguments, the conservative justices showed serious skepticism toward Hawaii's position. Justice Neil Gorsuch marveled at the fact that a lot of people who would normally react to historical anti-black laws like garlic in front of a vampire are now citing those very laws to promote gun restrictions, and directly questioned why the Ninth Circuit had relied on an 1865 Louisiana law that was originally adopted to disarm black people as a historical analog for Hawaii's modern carry restrictions. After oral arguments, legal analysts at the Duke Center for Firearms Law concluded that it seems likely the court will strike down Hawaii's law and constitutionalize the current default rule, making the status quo the baseline that determines which state actions are suspect. Now let's talk about the blast radius of this decision, because this goes far beyond Hawaii. If the Supreme Court strikes down Hawaii's law in Wolford v. Lopez, it would effectively impose a national mandate that guns are allowed into private businesses, open to the public by default, stripping all 50 states of the power to set their own default rules on private property carry. California, Maryland, New Jersey, and New York all enacted similar default swap rules on private property after Bruen. These restrictions have so far fared poorly in the courts of their respective jurisdictions. The domino effect does not stop at carry laws either. There is a real chance that appeals courts will not make significant moves in gun cases until the second half of 2026, after the Supreme Court has rendered decisions in both Wolford and Hemani. Legal experts note that usually there will be a lot of momentum to just wait and see, and once those decisions come down, the floodgates could open. On the assault weapons front, the Third Circuit case challenging New Jersey's AR-15 ban might be the first final appellate court decision that strikes down an assault weapons ban, according to Andrew Willinger, executive director of the Duke Center for Firearms Law. That is because the court's balance has tipped toward judges appointed by Republicans, including 2 new Trump appointees who debuted during en banc oral arguments. While Wolford focuses on where you can carry, the second Supreme Court case this term, United States v. Hemani, focuses on who can own a firearm at all. On March 2, 2026, the justices heard arguments in United States v. Hemani, a case from the Fifth Circuit where the appeals bench struck down the application of a federal law banning anyone who is an unlawful user of or addicted to any controlled substance from possessing firearms or ammunition. The case tests whether the Bruen framework applies to drug users, potentially affecting millions of Americans. These 2 rulings may come down at the end of term in June 2026, when the most controversial cases tend to be announced. The court's historical focus seems likely to yield nuanced results, striking down some regulations and upholding others. A decision will come by late June 2026, reshaping this corner of American gun law. Background checks blocked more than 300,000 illegal gun sales in 2020, and many of those denials were based on drug use prohibitions. That number could change dramatically depending on what the court decides. Here's the bottom line on where everything stands right now as of April 2026. The Supreme Court has already heard both Wolford v. Lopez and United States v. Hemani. Decisions are expected by late June 2026. Based on the questions asked at oral argument, legal analysts from the Duke Center for Firearms Law and other institutions believe the court is likely to strike down Hawaii's vampire rule, which would immediately threaten the same laws in California, New York, New Jersey, and Maryland. Simultaneously, the Third Circuit is poised to become the first federal appellate court to strike down an assault weapons ban, which would set up a nationwide circuit split and force the Supreme Court to finally take up the AR-15 question. The confusion in Second Amendment analysis will continue and expand as a result of these decisions. As one legal scholar wrote in SCOTUS blog, the Supreme Court has made a mess of Second Amendment law, and the 2 cases this term are likely to exacerbate rather than clear up the confusion for lower courts. But for gun owners in America, especially in Hawaii, California, New York, New Jersey, and Maryland, June 2026 could represent the biggest single expansion of carry rights since the Bruen decision itself. The nationwide block on these vampire rules may be coming, And when it does, it will change everything. Subscribe. Share this with every gun owner and every concealed carry holder you know. The clock is ticking, and by late June, nothing will look the same.